Welcome to Clarity, a podcast powered by the Thomson Reuters Institute. I'm Zach Warren, the Institute's Legal Insights and Strategy Lead. In each episode, we dive deep into a single question from decision makers and thought leaders from legal, corporate, tax accounting and audit, and government communities. On today's episode, we discuss the big question: what is the next step for businesses following the recent Supreme Court decision on tariffs? If you haven't heard yet about the Supreme Court's recent decision in Learning Resources v. Trump, dealing with the tariffs issued under the International Emergency Economic Powers Act, you might not be in the tax and accounting world. This case was closely watched for a number of reasons, including what it means for tariffs already paid. But businesses looking for both short-term and long-term clarity may have to wait a bit for the full picture, given how much is still up in the air. So what actions should business take now, both to comply with short-term regulations as well as to be flexible for potential long-term change? Today, TRI's Bryce Engelland chats with Karen Lobdell, Senior Product Manager Corporate Tax and Trade at Thomson Reuters, about what the ruling means for today's businesses, how it will impact international trade, and just what actions to take now in the midst of uncertainty.
Hello everyone, I'm Bryce Engelland, one of the content leads here at the Thomson Reuters Institute. When I'm not talking about law firms or technology, I'm also here talking about trade and economics. Why? Well, economics was my first professional passion. I have a master's degree in economics, and my master's thesis was on multilateral trade wars involving tariffs, which means that today's discussion is right up my alley. And I am joined here by an incredible guest once again. Karen Lobdell, would you like to introduce yourself, please?
Sure. Thanks, Bryce. My name's Karen Lobdell, and I'm a Senior Product Manager for Thomson Reuters OneSource Global Trade. I have responsibility for product management for a number of the products on our global trade platform, but I also spend a good deal of my time working on the regulatory side with our regulatory insights and updates. I've got roughly, let's just say over 30 years of experience in the trade in pretty much every sector. And now I'm focused more on the regulatory and the tech side. And I'm very, very pleased to be with you today to talk about this really exciting topic.
Oh yes, and it does feel like we're getting a slight sense of deja vu, because the last time you and I were together here on a podcast, it was April, and we were talking about then kind of a brand new swath of tariffs coming out, the way it was upsetting global trade, and kind of a certain degree of chaos it was unleashing on markets. And now here we are in the latter days of February 2026, and we have a Supreme Court ruling on some of those very tariffs, specifically the case of Learning Resources versus Trump. I was wondering if you could just give us a little bit of background on this case, why it matters, and maybe just how big of a deal it actually is.
Well, it's certainly a hot topic these days, and it's quite a big deal with regards to the trade because these tariffs that came out of the Liberation Day tariffs or the reciprocal tariffs and the fentanyl tariffs from last year were done under the IEEPA Act. And in this particular case, over the past not even a year, the government has collected close to $175 billion in tariff revenue related to these particular tariffs. And of course, the tariffs are paid by the importers of record, primarily US companies, and then how they filter down, perhaps as far as the consumer, are clearly an issue. And the tariffs range, 10% to 50%. They're quite high, and in the case of China, much higher for a period of time. So the impact financially to companies has been excessive. The Learning Resources case that was ultimately brought up to the Supreme Court after lower court rulings is a case that ultimately has deemed that these particular tariffs, the IEEPA tariffs, are deemed illegal by the Trump administration. In other words, he did not have the legal authority to apply the tariffs in this particular instance. And as a result, we're looking at a situation where we have this massive amount of tariff revenue that's been collected that could now be subject to refund. Now, keeping that in mind, there's clearly other tariffs and other methods that are used for assigning tariffs that still exist out there, but this was a substantial amount of money and a substantial impact to companies. So this ruling is something that people have been watching for quite some time and hoping for a positive outcome with regards to the tariffs. Now, that also raises certainly the question of, well, now what? And more uncertainty with regards to not only how will we move forward from this point, but are we going to see the administration take different paths to get to the same end? So whereas last year we looked at this, and when you and I spoke last time, there was all this uncertainty. We were living in a world of uncertainty, and I feel like we still are. And going into 2026, we are dealing with tariff uncertainty again. We have a ruling on one area, but we still don't know what the path forward ultimately will look like. And it's somewhat of a day-to-day, week-to-week, month-to-month scenario.
Yeah, it seems like rather than providing more certainty, the current ruling has just kind of ordered everyone to strap back in because here we go again. Um, there's a ton of different vectors we could look at this. Let's start from kind of looking at the perspective of domestic US businesses. For them, when we talk about the IEEPA tariffs being kind of lifted, the first thing that's going to come to many companies' mind isn't necessarily going to be a refund. It's going to be what happens to the tariff levels they'll be paying going forward. When I wrote a article on the very day that these tariffs, that the Supreme Court decision was kind of put out and the tariffs lifted, we were already looking at multiple sections that the Trump administration was talking about using to reimpose the tariffs in some point. And since then, the number of potential sections that have been referenced or the new tools that they might be reaching for has seemingly multiplied a little bit. So I was wondering if you could give us just a little bit of a window into what companies might be able to expect when it comes to future tariff levels in the US and maybe some pros and cons.
Absolutely. Well, there's certainly a number of legal channels that the president can take to impose tariffs. And those have existed in the past, but one of the downsides from the Trump administration's perspective with regards to some of these other avenues that can be taken is the time that it may take to actually implement them. The IEEPA tariffs was something that, as we saw with President Trump, he could flip a switch and turn them on. He would notify, in a proclamation or an executive order on Friday afternoon and make them effective at midnight Friday night. So the speed of implementation was very fast, which he liked. How quickly he can get something done. It also created a massive amount of chaos because businesses can't react and plan in that short period of time for changes that are that large. Now, going forward, it's very likely, and he has stated through a number of his cabinet leadership, that he has other avenues he can take. Those avenues are legal. They're slower in many cases, but they do provide him legal channels that he can use to implement tariffs. So, as you noted, that you have the Section 301 tariffs. Those were actually put in place for China back in Trump's first term. And those tariffs actually continued on through the Biden administration and into Trump's second term as well. And the USTR, Jameson Greer, has already indicated in multiple press junkets over the weekend that they are going to be expanding their look into the Section 301 tariffs. Now, there is an investigation process and a reporting process, public comment periods that come out with some of these, and that extends the time that it takes to implement, but they're perfectly legal to go down that channel. So following the proper procedures, those are tariffs that are more predictable for the trade from a planning standpoint and more likely to stick from any sort of legal challenge that might be raised. You also have the Section 232 under the Trade Expansion Act. Those we already have a good number of them in place. They tend to be country or commodity specific. We saw quite a few investigations that were opened last year, some that have actually been put in place. There are numerous others. I think there's probably about a dozen that are still pending right now. And our guess is that we'll probably see some more activity in that area as well. What we did see immediately following the ruling, within a few hours, was his use of Section 122. And this is the first time a president has ever used this particular approach for implementing tariffs. This is something that can be done very quickly, but there are limitations. Uh, there's a maximum of 15% that can be applied, and there is a limitation of 150 days, at which point, if they're going to be extended for a period of time longer than 150 days, there's going to have to be congressional approval. So it's really kind of a stopgap measure for him. He started at 10% when he announced it globally. And he has since come out on Truth Social and said he's going to be raising it to the maximum of 15%. We're still waiting for the legal documents, the proclamation to come out stating the 15%, but we anticipate that possibly by the end of today being Monday. So that's pending. Now, that would take us through July 24th of this year for 150 days, at which point Congress would have to do something. But more than likely, what we're going to see is he's going to use that 150-day time period to work through some of these other channels, such as a Section 232 or 301, so that he gets something more permanent in place, versus continuing to look at whether he needs to extend the Section 122 and go to Congress. And clearly, we know from his past that he typically doesn't go to Congress. He just does what he wants. So the likelihood of him extending 122 may be smaller, and he'll go down some of these other channels. There's also Section 338 with the Tariff Act of 1930. This is also something that I don't think has ever been used. It has some stipulations on it with regards to restrictions that have to be qualified for unreasonable actions by other countries, or discrimination by other countries against the U.S. So it's not something that we're likely to see, but it is another avenue that is out there as well. So there's a number of channels that we see here. And then he could decide not to use tariffs and look at trade remedies that are non-tariff related as well, which he's done in some of his trade deals. But these are all things that we'll be monitoring. The one thing I think that perhaps we're getting out of this, in addition to some of this chaotic approach with the IEEPA tariffs and these instant tariffs that were going up and down like crazy, is more of a timeline for planning for companies and a little bit more predictability. This is something you can work with if you have months to actually see the tariffs coming, and you can plan for that. And I think that's probably a good thing. And we know it's a legal channel, so it's less likely to be challenged down the line. Whether the 122 tariffs will be challenged is a question that's still outstanding.
Yeah, it definitely seems like there was a reason IEEPA was the first thing pulled out of the armory, so to speak. And because it gave them that ultimate flexibility to do kind of whatever, whenever, at whatever level they kind of deemed fits. That tool is now gone, and that is a bit of a loss. There are other tools available, and they're kind of maybe going to be patched together to create something similar that might be harder to kind of go through, might be harder to defeat through the legal channels. That does create some complications, though, because by setting a universal 15% tariff, Trump has kind of destabilized trade negotiations that were supposed to basically already be in lockdown and agreed upon, especially with the likes of the European Union. So how does this kind of impact the more international aspect, and how might current trade deals be impacted by the fact that the sword that was being threatened is now kind of gone?
It's an excellent question, and I think we don't have an answer yet. It's something we're really going to have to watch. These trade deals that were negotiated with President Trump in his current term are not traditional in the sense of doing, for example, a free trade agreement like we've seen with USMCA, where you have congressional involvement with the free trade agreements. These were framework agreements or deals that were primarily negotiated directly by Trump and a number of his cabinet members, Secretary Bessent, Lutnick and Jameson Greer. So Congress really was not involved at all. And these deals are very fluid in the sense that I think to date there's roughly 21 countries that are in some stage of finishing a trade deal or framework agreement with the US following the Liberation Day reciprocal tariffs. And they cover not only the tariffs themselves and those IEEPA tariffs as well as some others, but they also have a lot of other provisions in them related to other areas of focus from a trade remedies standpoint, whether that be labor laws, digital service taxes, other areas related to trade with that country that President Trump felt needed to be agreed upon as well. Now, all of those trade deals where IEEPA tariffs were involved, those IEEPA tariffs are now deemed illegal. So what to do? Well, in this particular case, if you listen to what the administration is saying over the weekend, they are continuing their ongoing discussions with these trading partners and these trade deals, and they anticipate that they're going to work through them in good faith, just as they have to date. And that's yet to be seen. Certainly, some of the trade deals, the ruling on IEEPA tariffs and the subsequent Section 122 15% tariff, for some countries, that's beneficial. You look at China or you look at Brazil, a 15% global tariff replacing what was an IEEPA tariff is much lower than what that country was paying on tariffs or what was being paid on the imports of products from those countries. Whereas for other countries, the 15% is higher. So, different countries are in different positions with regards to that. What I think we'll probably see, at least in the very, very short term, is that these countries are going to probably take a wait and see approach and kind of see how the dust settles with discussions before taking any next steps. But we really don't know what the outcome's going to be with that. The one thing we have seen over the weekend with the EU, which is clearly a very critical trade agreement that was announced in July of last year, is the Parliament was scheduled to vote tomorrow on the US EU trade deal. That has now been postponed till March 4th, I believe. So the Parliament has put a halt on that and pushed it out. And that's a pretty large agreement. We're not sure where that's going to go. It's definitely going to be something to watch. The implications on that falling apart or not moving forward are pretty strong. They're big issues. So it's going to be something to watch. And I think other countries are watching that as well. And certainly Trump has already commented on that on social media, not in a good way, and made some threats against countries that that try to take advantage of the ruling by the Supreme Court. So a lot of these trade deals are questionable as to whether they'll actually follow through as they're written. Or whether we're going to see changes on that. It's clearly an area that companies are going to have to watch closely, especially if they're doing business in those countries and those regions, to see how that could potentially impact their future business and their sourcing patterns.
Exactly. This is going to be just one more thing that many companies have to kind of look at and keep tabs on and somewhat plan for the unplannable around. Based on that, though, there is probably one big question that a lot of companies are now looking at, and they're wondering, okay, can I get then a refund for the IEEPA tariffs? What is that process looking like right now? What are some of the headaches that are already emerging? Are there even going to be refunds?
Well, that's a good question. The assumption is yes, the tariffs were ruled illegal, that there should be refunds. Now, how the process will work is the unknown at this point in time. I think most companies, especially large ones who are paying very substantial amounts in tariffs over the past months, have been thinking about this while the court case went through the process of obtaining a ruling. So they've somewhat been planning for the potential reality that this could become illegal and what should I be doing in the meantime. And clearly you want to be tracking any transactions that you've had over the past year where IEEPA tariffs were involved. Now, the Supreme Court is not dictating how refunds are handled at all. That'll be pushed down to the lower courts. and will land in the Court of International Trade as they handle trade-related matters. And we'll be watching for direction from the Court of International Trade with regards to how and if that process will work in a particular way. Whether that's going to be something that's going to be handled 100% through an administrative refund process with Customs and Border Protection, through channels like post-summary corrections and protests and reliquidation, or whether, court cases may be involved. There's, during the time that the Supreme Court was considering the case, there were roughly 2,000 court cases introduced at the Court of International Trade from importers against these tariffs as a precautionary approach. With regards to the tariffs and depending on what the Supreme Court came out with. So there's a lot of activity from that perspective. To be honest, I don't think anyone's 100% sure how it will be handled and how long it'll take for us to get an answer with regards to that. One of the things that was noted in Trump's press briefing on Friday was, his comments with respect to the fact that, refunds of tariffs could take years, for people to get their money back. And we all know from, President Trump's press briefings that, he says a lot of things, and where those things actually end up, is anybody's guess. But clearly the administration does have some say in the path with regards to refunds. So we'll have to watch that as well. What I will say from that respect is, clearly we don't know what the path is going to be. But it's going to be very, very important for companies, if they haven't already done so, and I think many have, is to make sure they're engaged with both their internal and any external legal counsel, because the scenario for each company is going to be unique and different, and their approach as to how they want to handle any potential refund process could vary dramatically. And it's really important that legal counsel is engaged and that you're speaking to those folks to determine the best approach.
Yeah, when Kavanaugh wrote his dissent in Learning Resources versus Trump, he basically said, "Hey, what about refunds? We've really offered no guidance on this. No one really knows what's going to happen." At least a few days later, that question is as answered as when it was asked. So it does seem like it's going to become a very complicated multi-year endeavor. The good news is $175 billion is quite the incentive to at least try and answer that. So it'll probably be something to watch over the next few years. But dealing with just the refund, companies have to deal with more than just the refunds in many ways. And so kind of as we approach the end of this podcast, Karen, I was wondering if you had any other recommendations for companies for navigating kind of a once again, even more uncertain landscape around global trade, tariffs, etc.
Yeah, I think there's a lot of suggestions and recommendations that, companies hopefully have already started to do some of this, but in the case that they have not, it's very important that you really get your arms around those transactions that have been impacted by IEEPA tariffs over the past almost 1 year. So you take a look at those transactions, identify what was paid, any potential interest that might be owed. All of that information has to be gathered in the case that the refund process moves forward in an administrative way, that you're able to document exactly what is owed to your company from that perspective. So making sure that you're tracking that information is really critical. And for those who are using global trade management solutions like a OneSource or some other methodology, these tools can absolutely help you track this information and produce reports and analysis that will be, much faster than the old methods of creating a spreadsheet, which could include hundreds or millions of transactions over the past year that you're going to have to be able to monitor and keep track of for the refund process. So that's absolutely critical. Engaging your subject matter expertise and subject matter experts. And this goes beyond just legal. Most companies, and especially the larger ones, are working with global trade experts on the consulting side, the legal side, the tech side. their own internal resources and multiple departments. It's really important that these people are engaged and that you're using every tool that you have in your toolbox as you try and pull all this information together. And that includes monitoring. These things are changing daily, weekly, monthly right now. So you have to have a method to track what's going on, not only with the administration through, the Department of Commerce, the U.S. Trade Representative, anything coming out of the White House as far as executive orders, proclamations, memorandums, fact sheets, et cetera, Federal Register notices, and CSMS messages from U.S. Customs on this subject. You've got to make sure that you're on those feeds where you're getting those update emails and that you're tracking that information so that you see what's coming as these changes start to materialize and we get a better handle on what those next steps may be with the administration. And I would also say it's a good opportunity, if you haven't already done it, to look at whether you're going to need to revisit some of the analysis on your sourcing patterns with some of these changes, any contractual agreements that you have with your vendors, your suppliers that may be impacted based on language that you may have in your contractual obligations with them that's related to tariffs from the past year. Those things need to be revisited as well. So if we thought we were going to have a slower year in 2026, I don't think we will. I think we're all going to be very busy. And I think this is going to continue to change as we move forward. And, it's maybe some of these, uses of Section 301 and 232 may allow for a little bit more predictability or timelines to implement practices and procedures to account for that. But it's still going to be a bumpy road going forward.
Yeah, it seems that once again, certainty has become a luxury for kind of the global markets. So I'm sure there will be even more to discuss in the coming weeks, months, and years. And so I wanted to thank you, Karen, once again for kind of jumping in on this conversation. As in many cases, this news is breaking minutes or hours before kind of we record this podcast. So thank you so much for sharing all this kind of vital information. So I want to especially thank all of our viewers for tuning in on this emerging topic, and I'll let Zach Warren take us out with the outro.
I'd like to thank Karen and Bryce for joining us today. There remains a lot to shake out regarding the recent SCOTUS ruling, but that does not mean that businesses should be in a holding pattern. Planning for a number of potential futures should be top priority, allowing for quicker responses whatever the future may hold. International trade may remain in flux, but that doesn't mean your corporate tax strategy has to be. Thank you as always for joining us for Clarity, powered by the Thomson Reuters Institute. You can follow or subscribe to this podcast on your favorite podcast platform, and don't forget to share with your colleagues, leave a 5-star review and a positive review on YouTube. For more data-driven analysis of today's professional services market and in-depth conversations with industry thought leaders, please visit us online at thomsonreuters.com/institute and follow us on LinkedIn under the Thomson Reuters Institute. Clarity is a production of Thomson Reuters, copyright Thomson Reuters 2026.